and this opening of this committee hearing is going to be a little bit disjointed. There's some razzle-dazzle. We're going to have votes here approximately at 10:15, and we'd like our friend from California and his guests to make sure that they get through their testimony before we have to head off to vote. So again, good morning. Welcome everybody to the Subcommittee on Railroads, Pipelines, and Hazardous Materials hearing regarding regulatory overreach in the railroad industry and the implementation of the Rail Safety Improvement Act. We are specifically we'll be focusing on the Federal Railroad Administration's final rule implementing the requirements for freight and passenger railroads to install positive train control, or PTC, system by December 31st of 2015. So I'm looking forward to hearing everybody's testimony today. And with that, I will yield to the chairman of the full committee, Mr. Micah.
Well, thank you, Mr. Chairman, and thank you for convening this hearing this morning of the Rail Subcommittee. This is a very important hearing, and I think it's very important that we put also a human face on some of the issues that challenge the Congress and the administration. I was requested by Mr. Gallegly to have a witness, and he chose this morning's first witness, and I think, again, that it's very important that the Congress try, when we enact laws, when the administration enacts regulations, that we do so in a responsible fashion to all parties. And we'll hear more about that from both his comments and the comments of his witness today. So again, thank you for convening this. I look forward to hearing from them and yield back.
Well, thank the gentleman, and I yield for the opening statement to the ranking member of the full committee, Mr. Ray Hall from West Virginia.
Thank you very much, Chairman Schuster. I appreciate you having these hearings. The first hearing the committee has held to oversee implementation of the Rail Safety Improvement Act of '08, which reauthorized FRA and mandated several significant rail safety initiatives, including those relating to the positive train control technologies. I have concerns with how the FRA is implementing the PTC mandate and whether the mandate can actually be implemented by the deadline provided in the legislation. We all want a safe system, but it has to be done right and not rushed. The FRA's final rule in many ways appears to go beyond the legislative mandate. For example, the FAA told the freight railroads they would have to implement PTC on rail lines where hazmat was transported in '08, even though the railroads may not use those lines to transport hazmat in 2015. Nothing in the law mentions '08. The only date is the deadline. With respect to the deadline, the law required the railroads to submit their implementation plans for PTC within 18 months of enactment. In these plans, the railroads are required to provide information about the extent to which they will implement PTC, provide a schedule for progressive implementation, and prioritize implementation on the basis of risk. Those plans have been submitted. But according to the GAO, while Amtrak has installed PTC on about 250 miles of track and 2 freight railroads have piloted PTC systems, other railroads have not yet begun implementation, largely because they are awaiting FRA standards of how the differing PTC systems must be interoperable. Further, although railroads have worked with suppliers to develop PTC systems, some components are not yet available, and the software needed to test and operate those components remain under development. Once they are developed, then they need to go through the testing in the field to make sure the system operates safely. On top of that, the financial situation for commuter railroads is tenuous. These railroads depend on funding from the federal government in states that are already suffering significant fiscal constraints, which make it difficult for them to cover the $2 billion in PTC costs, or worst case scenario, those railroads could start diverting funding from other critical areas such as maintenance, which could lead to other accidents, something I'm sure the authors of the legislation did not envision. With that, Mr. Chairman, I thank you for holding these hearings and welcome the witnesses.
Thank the gentleman. And with that, again, we're joined by our colleague Elton Gallegly from California's 24th District, and Miss Mackenzie Souser from Camarillo, California. Congressman Gallegly represents the Simi Valley of North Los Angeles, which includes Chatsworth, where on September 12, 2008, the tragic train accident resulted in 25 fatalities and 135 other individuals were injured. My thoughts and prayers are certainly with the victims and their families, in particular Mackenzie, who is the daughter of Doyle Souser, who was killed in that tragic accident. And we're going to begin with Congressman Gallegly and Mackenzie, and then after that we'll see if we have votes or not, and we'll come back after the vote. So Mr. Gallegly, proceed.
Thank you very much, Chairman Schuster. I want to thank Chairman Micah and my good friend, Ranking Member Nick Rahal, for inviting me to testify this morning at this hearing. I also greatly appreciate the fact that you invited one of my constituents, Mackenzie Souser, who will be here to testify as well today. Mr. Chairman, on September the 12th, 2008, a Metrolink commuter train and a Union Pacific freight train collided near Chatsworth, California, resulting in 25 deaths and more than 150 injuries, 135 plus serious to critical injuries, many of which were very catastrophic and will be lifelong injuries. This was the worst train accident in California history. I use the word accident lightly because many of us do not believe it was an accident, that it was something that clearly should have been prevented. Although there is going to be litigation relating to this matter, an extensive investigation conducted by the NTSB found that the operator of Metrolink system, Veolia Transportation, a French company, had a culture of ignoring risk and accepting rule breakings from the locomotive engineer who was driving the train. Here are some of the relevant facts related to the Chatsworth Metrolink tragedy. Robert Sanchez, the engineer who was driving the train at the time of the accident, had already been cited in 2006 for having his cell phone on while operating the train. This violation of written rules put Veolia on notice regarding Sanchez's cell phone usage while he was on duty. And only 1 month before the collision, the conductor on Mr. Sanchez's train saw Mr. Sanchez using the cell phone and reminded him it was a violation of the rules. The conductor reported his violation to the supervisor. However, no formal or informal action was taken against Mr. Sanchez to stop his cell phone usage. On the very day of the crash, just before the afternoon train runs began, the same conductor called another conductor asking his advice about stopping Mr. Sanchez from his dangerous texting conduct, since Veolia management had done nothing to stop it. The other conductor advised him to ask a union official the next day to intercede with Veolia's management. Despite this knowledge of cell phone use by Mr. Sanchez in the weeks leading up to the crash, Mr. Sanchez sent as many as 180 text messages every day he was on duty. Most of these text messages were sent by Mr. Sanchez while he was operating the train. The poster that we have over here illustrates the number of text messages just the week preceding this tragedy. In fact, on the day of the crash, Mr. Sanchez had already sent 143 text messages, and on the afternoon of the shift, 13 prior to the crash. And if you notice, there were fewer text messages on the day of the crash than there had been earlier in the week, only because the crash stopped the text messages definitely. 22 seconds later, in a blind curve, without any warning, the Metrolink train hit a freight train traveling 40 miles per hour head-on, derailing the lead locomotives and jamming the Metrolink locomotive backwards into most of the first passenger car. In an instant, close to 200 people were killed or severely injured. Mr. Chairman, I refuse, as I said, to call what happened on September the 12th, 2008 an accident. It was a tragedy, but it wasn't an accident. Should have never happened. For the victims and many families, this tragedy on September the 12th has been compounded by a federal law that limits damages relating to all claims arising from a passenger railroad accident to be capped at $200 million. The federal cap on all damages, which include Amtrak reform, included in the Reform Act of 1997, states that the aggregate allowable awards to all passengers against all defendants for all claims arising from a single accident cannot exceed $200 million. That was 15 years ago, and there was no indexing for the cost of living, and of course we all know that health care costs have increased significantly in the past 15 years. Mr. Chairman, the Chatsworth tragedy was devastating to 180 families in my congressional district. For this reason, I have called on the executives of Veolia to step up and at least cover the real damages, not the punitive damages, but the real damages caused by this tragedy. Veolia, a French company, is the largest transportation in the world. They operate rail systems that are subsidized by the taxpayers of this country, and they operate throughout the United States. Both public transportation entities and American public at large count on Veolia to operate safe transportation systems and act like responsible corporate citizens, and they have not done that. I therefore call on Veolia to take responsibility for the devastation they've caused and do the right thing by the people of this country who have lost so much through no fault of their own, only counting on public transportation to get them home safely from work. Again, I thank you very much for allowing me to testify today, and I would yield back the balance of my time.
I thank the gentleman.